Party senior leaders Sudhanshu Mittal. Mr. Mittal, this morning the Supreme Court struck down the earlier declaration of President's rule in Arunachal Pradesh, the formation of the Kalikulpul government, and restored the Nabam Tuki government. Will you accept this is not just an embarrassment for the Modi government, it's a metaphorical slap in the face?
Karanji, I have the entire judgment before me, which I am showing to you. This judgment does not even once mention about the president rule. So talking about striking down the president rule is the figment of imagination of
everything that happened after the 15th of December has been deemed to be unconstitutional. That includes the president's rule, it includes the Kalikulpul government, and when the clock is reversed to December the 15th, it means that everything that happened after December 15th is unconstitutional and illegal.
Sir, can I just read out the operative part before you make this kind of observation?
Go ahead.
Which is completely at variance with what the court has said.
Go ahead.
In view of the decision number 1 to 3 above, status quo ante as it prevails on 15/12/15 is ordered to be restored. Reference to 1, 2 and 3. What is 1? The order of the governor to prepone the assembly session. What is 2? The direction that the speaker will not take any action against anybody to alter the composition of the house. And 3, it talks about the decisions taken by the assembly on 16th and 17th of December. That's all.
All right.
So in relation to these 3 status quo ante, where is the question of president rule being struck down? And secondly, and allow me, let me just also point out to you that as we stand today, the president rule was not even there.
Absolutely, we know that, and no one said it was. We know that, and no one said it was. The phrase we used was the earlier declaration of President's rule. Let me bring in.
We are not in the dock, sir.
Well, let me bring in.
The central government is not in the dock.
That's your interpretation. Let me bring in Abhishek Singhvi, and then I'll bring in the.
Karanji, very sorry to say, but your facts are completely at variance with truth. At no stage has Mr. Rajkova assured the Supreme Court, and he has gone back on his assurance. Please understand that
was January, sir. It was January. It was an acknowledged fact.
Sir, I know it. I know this case much better. Sir, I know the case much better. Sir, please allow me. Karanji, but if the facts are not what you are saying, please have the humility to accept it. I know the facts of this case at the back of my hand. So don't challenge me on the facts. Now, what I am trying to tell you is, I so eloquently heard Mr. Abhishek Manu Singhvi talking all that. I don't think he has even read the judgment. Because I'll come down to the most important operative part of the judgment, which nobody seems to be even addressing themselves to it, but which I'll leave it for the last part of my debate. The issue is simple. The Supreme Court has interpreted the powers of the governor. Till now, there was an issue as to what the governor can do and what the governor cannot do. The Constitution said he can have discretions, and in case what he thinks is his discretion, that he has to act in his own discretion, is something which is his wisdom and that cannot be challenged. The Supreme Court has laid down, no, you cannot order the preponement. It has laid down principle.
I don't believe it was ever deemed by anyone that this was part of the governor's discretion. Mr. Rajkova assumed it was part of his discretion. No one else agreed with him. The Supreme Court has now told him it never was your discretion. You were wrong to do it to begin with. You were violative of the Constitution. This argument that you're presenting, that it was earlier deemed to be part of the governor's discretion, is an excuse you're devising to cover up for a terrible constitutional lapse by the governor. And that's why I ask, if he doesn't resign, should he not be sacked?
Karanji, there were 6 earlier cases where directions of this kind were given.
Wrongly so.
Let's not just make sweeping statements. Issue is, this is a constitution bench, and the constitution bench has laid down principalities. It has laid down what the law of land is, and it has, in this judgment, clarified the position of powers of the governor vis-a-vis the assembly.
Let's get someone else in on that.
The direction the governor
That's your argument. Let's see if Abhishek Singhvi agrees. Do you
No, no, my
accept the
argument-
argument that you're hearing from Mr. Mittal that all that the Supreme Court has done is to clarify what is the area of discretion of the governor, that earlier it was unclear, and therefore perhaps Mr. Rajkova was right in giving directions and right in preponing the assembly session, and that it wasn't, when he did it, a clear violation of
Sir,
the
ask him to
Constitution.
quote from the
Now,
judgment.
on clarification, it's been deemed to be. Abhishek Singhvi, do you agree with that interpretation? So, Abhishek Singhvi?
I think anybody who has either read the judgment, or knows an iota of law cannot possibly agree with what one is hearing.
No, I don't need any answers to work in my favor. There is a ground reality which you all don't seem to be appreciating. Because of the misconduct of Mr. Rahul Gandhi, who refused to even meet the MLAs with grievances for 6 months here. I mean, Kaliko Pul was here camping for 6 months and Mr. Rahul Gandhi did not even meet him. You have problems in the Congress and you want to blame BJP for that? That's strange. Can you imagine the disregard or the humiliating behavior which can be subjected to by the, for these MLAs?
And that justifies all that happened from the 15th of December onwards, which was reversed by the Supreme Court. That's what you're saying. Rahul Gandhi's refusal to meet, Congress's inability to handle dissent in their ranks justifies what happened.
I'm not even bothered what happened there. It is an internal matter of the Congress. They did not come and join BJP. BJP is not even a party part of the government. So if the problem of the Congress is there, if they are fighting, if they can't hold their flocks together, you want to blame us for what? And as I said, I take serious offense to what is being said here. Whereas the Prime Minister, see, the Prime Minister is not even named in this. There is no mention of the central government. There is no mention of anybody.
That's been acknowledged, Mr. Mittal. That was acknowledged in the question. So don't take offense at the fact that was acknowledged in the question. I'm going to go back to Abhishek Singhvi.
Explanation is this?
Before I take a break, I'm going to go back to Abhishek Singhvi to comment on the point made by Mr. Mittal that this whole situation arises out of the inability or failure or incompetence of the Congress to handle dissent, and as a result, when the Congress was collapsing, a situation that was impractical happened on the ground, and even though the Supreme Court has ruled by the Constitution, the reality on the ground was something else. That was an argument made both by Mr. Mittal and by Mr. Arimasundaram. A quick response before I take a break.
We have just heard two theories which will spell constitutional chaos even if accepted by implication. If there is instability in a government, if a BJP set of MLAs does not obey their master, or if a Congress set of MLAs doesn't obey their master, the answer lies in bringing a legitimate no confidence and winning it. What you call a constitutional sin of defections, what you call disaffections, and what you call using the help of a friendly central BJP government is not prescribed in the Constitution as a panacea for disgruntled MLAs. You tried it in Uttarakhand, you are trying it here.
All right.
And to give a kind of a political successively of everybody who looked at it. Just after all, who would have advised on Saturday in Uttarakhand to have President's rule? Not without the top central leadership with the Prime Minister heading it, with the Attorney Generals looking at it. Who would have advised this kind of action? Do you think Rajkova is competent to do all this? Now, you justify it by saying, oh, but what is to be done when the Chief Minister sitting has lost his majority? Just imagine the consequence of accepting that argument for constitutional chaos in this country.
Absolutely.
All the more reason when that happens, you remove him by legitimate means.
All the more reason when a Chief Minister loses his majority that you tested on the floor of the House, which is what Burmai laid down in 1994. I'm going to take a break and I'm going to come back and ask, was there an alternative that Mr. Rajkova overlooked? That the majority of a government whose majority you think has faded away must be tested on the floor of the House, not in Raj Bhavan, not in Rashtrapati Bhavan, not in Racecourse Road, and preferably not in High Courts and Supreme Courts. That's the question after the break. And secondly, with it, now that Mr. Tukey is restored, could he end up a Chief Minister who actually lacks the MLAs to survive? We'll be back in a moment's time. Virtually, the vast majority of his MLAs have actually switched sides.
You are giving him a second chance.
I'm not coming to you as well, please. Wait a moment, Mr. Mittal. You've had many chances too.
Please, now, this is not fair.
Let's not start quarreling like children, sir.
This is not fair.
Now, can I ask Abhishek Singhvi the question?
See, Karan ji, I had said that none of you seem to have read the judgment. And I'm confirmed with what has been stated just now. You just talked about the Speaker's order disqualifying the 14 MLAs. Now, do you know this judgment is most important not for the reasons which you have been discussing, but on the role of the Speaker. This judgment castigates the role of the Speaker and has laid down a fantastic principle which the Congress had been misusing all along for Arunachal as well as Uttarakhand. Now let me read it out to you so that you shall stand enlightened. It says, for the reason recorded above, we hereby hold that it would be constitutionally impermissible for a Speaker to adjudicate upon disqualification petition under the 10th schedule while a notice of resolution for his own removal from the office Speaker is pending. See, what was this entire issue about?
Mittal Saab,
there was a notice
what you're ignoring is when you restore the status quo to 15th December,
Sir, if
a
that is your
decision taken on the 7th becomes valid.
Sir, you will allow me to complete or not? Or you have a premeditated mind? You give everybody a chance, you will not let me even explain the constitutionality of things. What is wrong, Mr. Thapar? Here is the Supreme Court which has maintained in this judgment itself that those 14 are not disqualified. Please understand, read the judgment. Secondly, it says the Speaker cannot adjudicate on 10th schedule if his removal petition is already pending. He has upheld our position. It has castigated what the Congress was doing all through and has now prohibited the Speaker. This is the main operative judgment which which establishes a principality of misdeeds of the Speaker. You want to conveniently overlook it. And let me tell you one thing. The 14 people who were disqualified have been restored by the High Court. So there is no status quo ante in this. Please don't get misguided by what people are telling you. Please read the law.
All right.
That's my humble thing. Now, as we stand today, there is a PPP which has... Allow me, sir. Allow me to finish. This is not fair. There is a People's Party of Arunachal which has a strength of 30, which stands where it is. There is Congress. There is 11 MLAs of BJP. That makes it 41. There are 2 independents. Congress has a strength of only 15. Now, if 15 is majority, I thought democracy is rule of majority, then so be it. As far as Mr. Singhvi's comment, that, you know, we should have gone for the floor test. You know, thrice the Supreme Court asked Mr. Singhvi as well as the other lawyers if they were willing for a floor test and they refused. Go through the proceedings. Sir, they are the people who perpetrated the misconduct.
All right.
This entire litigation was
now
about the role of the Speaker, his misconduct. And he has been castigated. This is page...
No,
sir,
please don't start reading more pages. I take your point, he's been castigated, but I need to now bring in someone else, Mr. Mittal, because it's unfair that you should be the only one speaking. What you're hearing from Mr. Mittal, Mr. Sundaram, is that far from this being an embarrassing outcome for the government, far from it being a slap in the face, it is actually a situation that corroborates A, the steps the government took, and B, it ensures that whenever the floor test happens, the majority will be with those that Mr. Mittal and the BJP support. He calls them the PPA. Do you accept Mr. Mittal's interpretation? Because it is totally contradictory of the interpretations given to me both by Dushyant Dave as well as by Mr. Abhishek Singhvi. So do you agree with Mr. Mittal or not? That this is not an embarrassment for the government, and as far as the PPA is concerned, Karan, and the BJP, they have a majority.
I'm sorry. Karan, without a doubt, look, politically, a decision of the Supreme Court reversing a decision of a government on a matter like this, restoring a status quo ante, is an embarrassment for the government. Let's not run away from that. But the fact